case briefs, and so much more. LSData's got what you're looking for.
In 1960, the United States District Court for the Southern District of New York heard the case Colon v. Trinidad Corp. The case revolved around the responsibility of employers to provide a reasonably safe workplace. Seaman Rafael Colon sued Trinidad Corporation for damages and maintenance and cure after 2 accidents aboard the SS Tillamook. However, one claim for damages was later abandoned. The focus of the case was on an accident on November 25, 1957, when Colon slipped and fell while chipping the bulkhead at the bilges, injuring his neck. He claimed that he had been standing on a dry turpentine can while working, but the court found this physically impossible. Instead, they determined that Colon had used the can as a seat while chipping rust and stepped on it to go for his coffee when it gave way beneath him. Colon also claimed damages for injuries sustained due to a slippery condition on the vessel, but the court found no evidence to support this claim. The court ultimately ruled in favor of Trinidad Corporation, crediting them with wages and maintenance paid to Colon, along with any other wages earned and time spent as an inpatient. In case of disagreement, the court would calculate the disputed items. This ruling constituted the court's findings of fact and conclusions of law, reinforcing the notion that employers must provide a reasonably safe workplace but are not responsible for every accident that occurs.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.